This podcast is not intended as legal advice. If you're in need of legal services, please contact 602-375-6752 to set up a consultation. You're listening to the official podcast of the Law Office of Libby Banks, Estate Planning, Wills, and Trusts. Your estate planning attorneys in the Phoenix Valley.
Welcome to the podcast for the Law Office of Libby Banks. I'm Libby Banks, and I'm here with our other attorney, Allison Gloss.
Hello.
And with Stephanie McLeester, a family law attorney with McLeester Law. So tell us a little bit about yourself, Stephanie, and about your firm, which you've just started recently.
Yeah, so I've been practicing exclusively in family law for the last 6 years and recently ventured out on my own to start my own firm with just an emphasis on treating the clients, treating anybody that helps our firm, whether it's staff or contractors, with the respect that they deserve and family law. So it's been a very fun ride thus far.
Yeah. Well, we've always enjoyed working with you in the past, and so we really wish you all the best with that new venture. The other thing that is interesting about you is you also are a boys baseball coach. So tell us a little bit about that.
Yeah, but we can call them boys. They might get offended by that. It's technically men. It's an adult men's baseball team. There's various leagues throughout the valley for adult men's baseball. So and it's great with Phoenix being such a melting pot. You do get a lot of those guys that played Division I baseball, that played minor league baseball, even some former pros. And so it's fun. We can even play year round, and it's just great because I've been coaching baseball for 15 years. So it's my kind of breakaway from the rush of the middle of the day. So.
Yeah. And how did you happen to get into that? Tell us a little bit about the background.
Yeah, so I actually chose to play baseball instead of softball when I was a kid. So I played up until puberty basically made it not possible. And then my husband started the club team at our college, our university that we went to. So, basically, if you weren't quite good enough to play for the NCAA team, but you still wanted to play ball, you could play club and still travel regionally to other schools and play. So he started that, and I took it over because he was a year ahead of me. So I took that over. And then when we moved out to Phoenix, he tried himself to just play, and that's it. But then eventually the team needed a leader, so he took that over, and we kind of just continued the same pattern of he gets it going, hands it off to me, and that's just how it's gone for us for 15 years.
Awesome. Very, very fun. That's a fun and interesting fact about you.
Yes.
Where are you from?
I'm from St. Louis originally.
Oh, very cool.
Yes.
Nice.
Good Midwestern girl.
Yes. Midwest, South, depends who you talk to. So I went to school down in the Boot Heel. So like Kentucky, Tennessee are right there. So it is very different, St. Louis versus where we went to. Very different kind of environment and cultures.
Yeah, absolutely. Well, we're here today to talk a little bit about the intersection between estate planning and family law. So I thought I'd start with a little bit from my point of view of what we see beforehand, and then we can switch to what we see afterwards once a divorce is complete. Really looking specifically at the divorce situation. So one of the things that we see often is clients are coming in for the first time, either right before they filed a divorce or after they've already filed it. They're realizing that if they don't have a health care directive, that their spouse might still be able to weigh in on whether to pull the plug, among other things, but also just health care decision making sure that they have something specific there. And then the powers of attorney. So a lot of people don't think about estate planning as being important for incapacity planning. We're just thinking, well, what happens if I pass away? But an important piece is what happens if I'm incapacitated? And in particular, with regard to the divorce, what happens to that? What happens to the divorce? What happens to my legal rights? How can I keep moving forward if I'm on the verge of a settlement and I just haven't signed it yet? Can somebody sign for me if I'm incapacitated, if I'm in a car accident and now I'm in a coma? I might come out. It'd be nice to have things continue on. So it's an important piece to have that power of attorney for somebody who can manage your finances, deal with the divorce, deal with other legal matters along the way. Even if that's all we put in place, we don't worry about, where are the assets going when you pass, because they might be jointly owned, for instance. So tell us a little bit about conversations you might have with clients as they're beginning and thinking about their planning, not just for the divorce, but for their making sure they're taken care of.
Yeah, so when we're doing an intake, we're asking a lot of questions as far as what their financial situation is. And a lot of the time we do need to explain the difference between community and sole and separate property, because Arizona is a community property state. So we're educating while also doing an intake. And understandably, people are usually emotional or nervous, and they're not even prepared to necessarily tell us everything that they have. So an issue that we've run into is being 3 months in, 6 months in, at the end of the divorce, and it's, oh yeah, well, everything's in a will or everything's in a trust, more specifically a trust. And we're like, okay, good to know. Would have been better to know before. For the most part, doesn't really change things, but it does change how the verbiage of that divorce decree needs to be. Most people aren't thinking about, to your point, a medical power of attorney, medical directives, financial powers of attorney. They're not really thinking about that. And if they don't tell me that these things exist or don't exist, then I can't guide them along the way. So, recently, upon disclosure throughout our dissolution process, I see a power of attorney. And I said, I think we might want to revoke that. I can only direct you on the things that I know exist. And oftentimes we don't know what questions to ask for the specificity if you don't provide it, right? Every case is different. It's unique like a fingerprint, right? So while we have the general questions we're going to ask, if we don't know that, well, yeah, we have the house, but it's in a trust. Okay, so it's in the trust name. Okay, well, that's technically another entity. We need to talk about that, right? So what we want people to tell us is, answer all the questions that we're asking, but also think about these other things that you might have. Do you have that power of attorney? You might be surprised. Some people would actually be okay with their ex or their soon-to-be ex still making those decisions for them, because at the end of the day, that's still somebody they loved, or still somebody that knows their health history better than anybody else does, or something like that. But more often than not, that's not the case. So we do want people to think about that so we can send them to you.
Yeah, absolutely. Yeah. And so then if they if they filed for divorce, they do have the right to do a power of attorney that's different, a healthcare power of attorney, and they can even do a will. Depends on how the property is held, as to how effective that would be to actually give it to the people they would want it to have it. But they can do that.
Yeah, they can do that. And they could have a will that maybe they're just kind of throwing into place because maybe I anticipate, hey, unfortunately, this just isn't going to be a 4-month thing. This is going to drag out for a while. And the longer it drags out, the more statistically something unanticipated could happen, and you want that to be in place. But what I do tell people is they need to understand that just because you've designated a beneficiary for something in your will, trust, whether we do it in the middle of the divorce or long before, at the end of the day, community property is going to be community property, right? There's still going to be a designation for what your spouse is entitled to if that divorce isn't finalized. But if you have nothing in place, right, that's when you're gonna be heartbroken on the other side of things, realizing that person that you were leaving behind is still gonna get that chunk that you didn't want them to get.
Right, right. Yeah, and so if, for instance, just using a home as an example, because that's the hardest one to try to transfer anything on your own, if it's held in co-ownership, whether community property or joint tenancy, with that right of survivorship, it doesn't matter if a divorce is pending or even if a divorce has happened. There's some rights there, and potentially the right of that spouse to inherit that property. In particular, if the divorce is still pending, because until there's actually a decree saying you are divorced, you're still married, right?
Yeah, exactly. And people don't seem to understand that, you know, we tell people with this community idea, as soon as you start the divorce and serve the other person to start that paperwork, your community severs. It's over. Therefore, anything you acquire after that, even if you're still married while we're going through the process, that's your sole and separate. But everything before that designation doesn't change. You are still legally married. Now, there are temporary agreements that we can reach that are still legally binding, still a court order. So if the parties agree early on, yes, hey, this is how we're going to divide the house, we can put that into an enforceable court order. That's just as enforceable as the decree, but maybe we just don't have the rest of it figured out. Maybe we don't have the child custody part of things figured out. So it's okay to piecemeal along the way as you make those minor agreements, again, just in case.
That's great.
So what goes into that bifurcation of assets? For example, if somebody had a 401k before the marriage, and then once they got into the marriage, it had accrued so much in dividends and whatnot. So
Sure.
who does that separation?
Yeah, so it depends on how you want to go about it. And investment accounts are difficult, right? Because you could, we call that commingled, right? Where part of it's community and then part of it's sole and separate, especially if you do have a longer divorce process, right? And then to your point, right, you have the dividends, you have the interest that's growing, and then how do you separate that out? So we have something called a quadro attorney, a QDRO attorney, qualified domestic relations order, or depending on the type of account, it could just be a DRO, domestic relations order. And those are very specialized attorney. I can probably count on two hands how many we have in the state of Arizona that goes through and actually does those calculations and does the documentation, the order drafting, and the communications with the plan administrators to get those actually divided.
Wow. I've always wondered that.
Right. And the other thing is, and I'm not sure I know the answer to this, so if I filed for divorce, which I'm not going to do, if someone has filed for divorce and they have a 401k or they have an IRA, their spouse is named, they're still the spouse. So I don't think they can change that designation at the point of filing a divorce. Would you agree, or do you know?
So one of the documents that gets kind of put in that initial packet to initiate the dissolution is a preliminary injunction. And the preliminary injunction is just an order of the things that you cannot do until the divorce is finalized, right? You cannot make any changes to any insurances. You cannot cause somebody to be removed from insurance. You cannot conceal, hide, give away community assets, but technically you can change the beneficiary on those types of accounts. If you have a life insurance policy or life insurance annuity policy, you can't do that because that is causing somebody to technically be removed from a life insurance policy. But if it is a 401k or IRA with a designated beneficiary, those you can change.
Yeah. So then it would be up to, for instance, if I have my accounts with Fidelity, an IRA with Fidelity, sometimes they won't, even if the divorce is pending, I think, because they're, just the federal laws, I think, require that.
Right. And that's the difference we run into, the differences between federal and state laws. I tell clients all the time, the federal courts don't care about your state court order, right? It comes into play with creditors, with IRS and how taxes are filed and things like that. The feds are going to do what they want to do. They don't really care about your state order. That you could have some type of remedy in state court, sure, but the federal court, they don't care.
Right. Right, absolutely. So, so then in preparation for speaking today, I had double checked because I was aware of a case where somebody actually had created a trust and was making transfers to that trust just for purposes of estate planning. I think most family law attorneys don't want their clients to try to do that, but it appeared that that actually was permissible to create a trust, and certainly with regard to separate property that is very clearly separate property. You know, my inheritance that I've kept in my name, creating that trust and going ahead and transferring that in there so that you're directing where that asset goes is permissible. What's your take on somebody who is, let's say it's a second marriage and they've got kids from a previous marriage. They really want their kids to now inherit their portion of the community property and their separate property. What's your feeling about doing that during the course of the divorce?
So, to your point, family law attorneys do kind of approach some of this differently, but it is permissible. I think it's just kind of maybe what's easier or what's less combative for the process. So to your point, the sole and separate property, you can do whatever you want with any of that. The community property, this is where family law attorneys will differ. So for example, let's say you have a checking account, there's $50,000 in there when the divorce starts. A lot of family law attorneys say, do not touch it. Do not do anything with it. I am of the position where I'll tell you, the law is clear. You're entitled to one half of that. So you can take your one half. If you want to take out, make sure you only take out your one half. And then you do with it what you want. If that's putting it into a trust, that's putting it into a trust. And theoretically, you can do that even 6 months in, right? Let's say you just have a brokerage account and $100,000 in there. Okay, well, you're entitled to one half. So if you want to move that and put that in a different account that's going to be invested a certain way, you can do that as long as you only take your one half. And that's just the emphasis that I put on it. Now, when it comes to a trust, and if you're, again, to use that word, that commingling, where you're taking the community and you're adding it in with the sole and separate, now we're mixing the two. However, with the trust, the case law says we'll just trace it back to what it was. So maybe we don't create an account that, at Fidelity, that's a joint tenants with right of survivorship or something. And we put some sole and separate funds and community funds into that same exact account that's held by the trust. Maybe I don't want you to do that, but it's okay for the trust as a whole to hold a combination of those things, so long as we can easily trace it back to what's community and what's sole and separate.
Yeah, absolutely. And I know that, one thing that, family law attorneys are cautious about, you just don't want to piss off the judge. So do not do things that, go over the line. Towing the line might even be a little bit, not a good thing, just because you don't want the judge then to see you as a perpetrator of bad acts. So.
Sure. Yeah. And every judge is different, right? And in Maricopa County specifically, we have more than 30 judicial officers, but we have 30 judges spread throughout our 4 superior courts. And each of those judges have 800 plus cases. So you don't want a judge to necessarily remember you under those circumstances, right? If the judge remembers you, that's probably not a good thing. But there are some judges where you can toe that line and you can do okay with it. And you have some judges where don't even toe the line, because even though you technically didn't do anything wrong, that's not that judge's personality, right? So that's where you want to listen to your attorney and know your judge. I do advise my clients depending on the judge. Now, maybe I don't have that much experience with them, because that's just how the lottery system works with who gets what case. And some judges I do have more experience in front of than others. But that's where, yes, you want to listen to the attorney on that, especially if they are very familiar with the judge, and just not get too cute with it.
Yeah, absolutely. And certainly what is absolutely prohibited is moving things out of your name into other names or hiding assets, that sort of thing. So that's really what that injunction is designed to prohibit. And if you do it before you file the divorce, you can get in trouble for that as well.
Yeah. So technically you can only get in trouble for doing it after the case is started from a preliminary injunction perspective, right? You're not necessarily going to get in trouble for doing it in anticipation before, but I will find it. I've kind of enjoy the witch hunt to go and find those things that you were trying to hide, because I will find it. I have a lot of resources available, a lot of great people that help me out, and I will find it. And while you're necessarily, the preliminary injunction is what tells you can't do that. So while you're not necessarily going to get in trouble for doing it before, again, you don't want to piss off the judge. And that's going to piss off a judge if that ends up coming out because you didn't settle that you did that. That's not going to go well for you.
Yeah. Absolutely. Absolutely. Well, let's talk about post-divorce, because we actually have had some cases, not cases because we were conflicted out, but some situations where we have discovered after the fact that clients of ours have gotten a divorce. So they came to us, they did a joint trust, they did their entire plan, they did a good job, they funded everything into the trust, so their house is in the trust, maybe the cabin's in the trust, their stock accounts, all of that, all in the trust. They get the divorce, sometimes without a good attorney or no attorney guiding them along the way, and they forgot they had a trust. They didn't realize they needed to move the house out of the trust into whoever's name it was supposed to be in, or into their names but without right of survivorship. And it causes a huge mess. So it is so important for them to let you know if they've got a trust, so that they can think about, do I need to revoke it now? Do we need to go ahead and jointly move things out of the trust? But certainly, once we have a decree, making sure that they deeded it to where it's supposed to go, and not leave it in the trust where if one of them passes, which we have had happen recently, it's a mess. It's a mess. So the law does not allow your spouse that you've divorced to inherit from you. Mm-hmm. They can't serve as your trustee. They can't serve as your executor under your will. But if that's the only person you named, you have a problem. Mm-hmm. So because now nobody's named to handle these things, and yet you have this will or you have this trust that supposedly is your wishes, but might not be your wishes anymore. So so important for them to, let you know, so that you can give them some guidance on what do we do now that we have this agreement and the court has approved it.
Yeah, and we had that conversation previously, right, where it's like, we can fix it, but oh my gosh, the mess that's going to be left, right? So yes, I want to know that there's a trust so that I can mention it when I'm drafting up that decree for you. I can mention the trust, and I can mention, because sometimes when there are mutual children, for example, sure, we want to change some aspects of the trust, but we're not completely revoking the trust, right? We're not completely getting rid of this trust, and now we're creating two separate. So I want to know what's in the trust, what's going to be moved, what's not going to be moved out, because then I can put it in the decree. And now there's legal instructions. Now there's a court order on what's going to happen should somehow somebody passes before it can be executed. And on the other side of that too is in all of my decrees, there is something, not necessarily a trust or a will or something like that, right? But maybe specifically the changing of the deed for the house, for example, I'll say that you have 30 days, you have 45 days, you have 60 days, depending on the situation. We will have certain cases where for some reason they're not actually doing anything for a year or two. Started to become very popular over the last couple of years with people wanting maybe the mother of the children to still get the house, but we know that mother can't refinance because our interest rates were at 8%. So you have the husband or the father that's saying, okay, I'm okay with you waiting a couple years to refinance it because I know that the interest rates make it unaffordable. And then, once we refinance it through title, that's when we'll change title. And now you have another mess, right? So it is this forward thinking that you have to have so that I can almost write just about anything in these decrees. They don't have to be super strict and template and structured. I can get very creative with it. And it's something people need to think about and anticipate.
Right. Yeah, that's one of the things we do. So I'm so glad to hear you say that is, when we're doing the trust, we're doing, and what if this, and what if this, and what if this. So being able to structure that in the decree so that we don't have, gosh, we didn't think about this, and the decree doesn't answer it, so now we're back in court. And the same thing with the estate plan. We don't want to be either at a loss, so now we have to get court instructions, or have it not actually be what we know the person wanted, because it just wasn't specifically stated that way. So that's great to be forward thinking along those lines as well. One thing I'll mention is that we now have a page of our website called libbybanks.com/deed-questionnaire. So that is a place where someone who needs a deed, for instance, to transfer from one party or from both parties to one, out of the trust potentially, those kinds of things, they can put in their information, and then we will reach out to them to let them know if that's an appropriate one for us to handle, what the cost will be, and that sort of thing. So particularly, we have had situations where the couple maybe didn't use an attorney because they already had agreed on everything, but they didn't do the deed to actually make the transfer. They thought the decree acted in that place, and that's not what the recorder's office shows at this point. So being able to assist either other attorneys who don't actually prepare the deeds, who prefer to have somebody else do that, that's available for us, and so we're always happy to do that. So.
Yes, and please record your deeds. Please record your deeds.
Record them as well. Don't just sign them.
Please record them, yes.
All right. And we take care of that as well, so that if indeed we say, yes, this is appropriate, we'll prepare this deed, we will make sure it gets signed, notarized, and we will get it recorded. That's, very good. So, well, any last thoughts, Stephanie, about either your practice or estate planning or the state of the world in general?
It's just there's so many people out there that can help you, and the more information that those people have and the more you connect them, the better. Some of my favorite cases are I'll ask a client, because I don't want a client having to guess on what they need to do. Do you mind if I talk to your financial advisor? Do you mind if I talk to your estate planning attorney? Do you mind if I talk to your banker? That's your team, right? So let your team work together, because that's going to close up any of those holes, any of those gaps, any of those miscommunications, and it's going to make everything so much smoother.
Right. Absolutely. And I've mentioned a couple of times using, just doing your own divorce. I don't recommend it, unless you don't own anything, that might be a different situation. But it's so important to use professionals for these things. Think about what Stephanie said about, being forward looking. You may not be thinking through everything when you put your own decree together. So it's a great idea to use an attorney, even if you've gotten everything agreed, to have somebody look it over and really give you those thoughts. And of course, we always say, please use an attorney for your estate planning. We know things you don't know. We think in a different way than sometimes you might be thinking. And we can really make a difference for your family, because you won't be here, but your family will be, and they'll be dealing with the mistakes that you might have made. So, well, thank you so much for joining us for our podcast today. Again, we're the Law Office of Libby Banks and Stephanie McLeester with McLeester Law, and we appreciate you coming to listen today.
Thank you for listening to the official podcast of the Law Office of Libby Banks. If you're in need of an estate plan, please reach out to our team by either calling 602-375-6752 or emailing info@libbybanks.com. You can follow us on Instagram and Facebook. Just search the Law Office of Libby Banks. Free consultations apply to new and existing estate plans only. If an estate plan is not completed or was prepared by a third party, revisions will be given at an hourly rate. This has been a T-Door production. Music by Track Tribe.